Hey everyone, welcome back to the Business Immigration Benchmark. I'm your host, Laura Blaneers. Coming up on today's episode, we're chatting all things PERM processing delays, what's causing them, the current state of the PERM processing delays, the impact to corporate immigration programs, and then we'll share some solutions for HR and global mobility professionals to use at their companies in hopes of mitigating some of these PERM processing delays. I'll also dive into the case management software use case for making some efficiencies with U.S. corporate immigration PERM programs. And then finally, my producer Finn will hop on to introduce some case scenarios based on real-world corporate immigration programs. We've anonymized the programs, but these are real-world scenarios that hopefully in listening to both the problems and the shared solutions, you can take back some insights into your corporate immigration programs to provide some relief to any of the challenges you might be facing that are similar. I also want to give a bit of a tease for next week's episode, where I'll be breaking down the results of WR Immigration's March benchmarking survey. The survey is currently in the field for a few more days. We're collecting responses from verified HR, immigration, and global mobility professionals on what H-1B alternatives their companies are leveraging in 2024. So stay tuned for that next week. But really quick, before we jump in, please follow the Business Immigration Benchmark on Spotify or subscribe to WR Immigration on YouTube. That way you'll get notified every Monday when we release new episodes. If you haven't already, follow WR Immigration on LinkedIn so you can get updates about this podcast, as well as listen in to all the other conversations my colleagues at WR Immigration are leading on that platform. As you know, the best way to get a hold of me these days is through DM on LinkedIn. So if you have any comments, feedback, questions about the podcast, this episode, or suggestions for future episodes, please shoot me a message on that platform. For those of you who have reached out to give me feedback, thank you. Let's keep it coming. So with that, let's dive right into our topic, PERM processing delays. PERM processing delays are one of the most constantly reported pain points for folks in the industry. I hear it from my clients, I hear it from my colleagues, and that it's because the PERM processing with the DOL is just horrific these days. As most of our listeners know, PERM is the acronym for the online filing system with the Department of Labor. And the Department of Labor is the government entity that oversees the pathway for EB-2 and EB-3 labor market sponsored green card cases. So this is where a company, if they want to sponsor a foreign national through the labor market test, they follow a very specific compliance protocol that is overseen by the Department of Labor. So when I'm talking about PERM processing delays, I'm really meaning the delays with the Department of Labor and each of the various compliance steps that is overseen by the Department of Labor. So whether your U.S. immigration program is large or small, has suffered reduction in force or layoffs in the recent past or not, the stress and frustration of the PERM processing delays, it continues, and it's across the board. Since 2020, we have seen processing times continue to push longer and longer. So DOL recently reported processing times for both PERM applications, that's the Form ETA 9089, and prevailing wage determination processing times. So a few facts and figures. As of January 31st, 2024, the National Prevailing Wage Center, this is the entity within the Department of Labor that processes prevailing wages, is currently processing prevailing wage determinations filed in September 2023. So approximately 7 months to process a DOL issued wage. So that's an OES based wage. You know, I'm seeing PWDs or prevailing wage determinations issued at 5 months, 11 days. So just under 6 months. For example, just last week, I received a prevailing wage determination. We filed it September 29th, 2023, and that was issued March 11th, 2024. So that's a recent example of some processing times that I'm seeing with my clients. But like I said, Department of Labor is reporting the average processing time for PWDs at 7 months. If you're pursuing a non-OES based wage, meaning you've suggested a private salary survey like Radford or Towers, your prevailing wage determination or private wage surveys are taking approximately 1 year to be issued. So pretty substantial processing times there. As of February 29th, 2024, the DOL reports the following for PERM processing times. DOL says it's currently working on applications filed in February 2023 or earlier, on average, adjudication time of approximately 401 days, so just over 13 months. And that's right in line with the approvals that I'm seeing. Last month, DOL reported average processing time of approximately 393 days. And that's exactly what we're seeing. Like every month that the Department of Labor is reporting out new processing times, it continues to tick up higher and higher, just slightly every month. And that's where we're getting these almost over 13-month PERM adjudication timeframes. If you have an audited application, DOL is reporting their processing applications filed December 2022, and that the average processing time for audited applications is 505 days, so almost 17 months. I regularly deliver PERM processing updates, trainings to my clients because the labor market test, the PERM process is quite complicated. And every time I'm delivering the training, I have to update the materials to reflect these increased processing times. It's quite depressing. To put it all together, with the DOL's information, we've got 7 months for a prevailing wage determination. That's the average. 2 months for recruitment. That's 30 days of the active recruitment, 30 days of the cooling off period, which is the minimally required recruitment period for the process. 13 months for PERM adjudication. Altogether, so if we were running that process sequentially, that's 22 months to secure a PERM adjudication. That's, again, best case scenario, assuming these processing times don't increase, which, as I'm noting and as the DOL continues to report out every month, those processing times tick up a little bit longer each month. What's causing the delays? So for context, in 2004, DOL expected 120,000 PERM applications to be filed each year and projected it would take 60 days to process each application. It'd be nice, right? Well, DOL was right about the estimated PERM applications, and for the last 5 fiscal years, DOL has not received more than 120,000 applications. I want to credit this information to Brad Benet and Stephen Brown. They recently deposed the head of the department within the DOL that's responsible for the PERM adjudication and PERM processing timelines. Brad and Stephen are litigating this issue and challenging current PERM processing times. And the administration testified that DOL has 12 full-time analysts on PERM applications, with a flex team of 6 more analysts who rotate between PERM and H2A, H2B cases. H2A, H2B are seasonal worker cases. But these analysts decide 50 PERM cases a day, approximately 8 minutes per PERM application, which should be 12,000 PERM cases adjudicated a month. So what's causing all these delays? So for context, in 2004, Department of Labor expected 120,000 PERM applications to be filed each year and projected that it would take 60 days to process each case. DOL was right about the estimated PERM applications. For the last fiscal years, DOL has not received more than 120,000 applications. For example, fiscal year 2018, just over 116,000. Fiscal year 2019, 104,000 approximately. 2020, 108,000 approximately. Fiscal year 2021, just under 100,000 with 94,000. Fiscal year 2022, 102,000 approximately. And in fiscal year 2023, 119,000, just over 119,000. I want to credit Brad Benet and Stephen Brown for these facts and figures because they've recently deposed the head of the OFLC, so the head of the subdepartment within the Department of Labor that manages PERM adjudications. And Brad and Stephen are litigating the DOL, challenging current PERM processing times. And this is taken from the administrator who testified that the DOL has 12 full-time analysts on PERM applications with a flex team of 6 more analysts who rotate between PERM and H2A, H2B cases. H2A, H2B cases are seasonal worker cases that also require a prevailing wage before proceeding with those filings. These analysts decide 50 PERM cases a day, approximately 8 minutes per PERM application, which should be 12,000 PERM cases a month, which would surely be enough adjudications to cover 120,000 cases per year. So we're rooting for Brad and Steven to hold DOL accountable for reasonable processing times, because it's absurd that the DOL is taking 13 months to deliver adjudications when, by their own projections, they're staffed with enough analysts, and their projections also confirm that these cases should be adjudicated within 60 days. Can you imagine? As the data Brad and Steven uncovered, the DOL does not have increased workloads. In fact, they've never surpassed 120,000 cases per year. So this is definitely something the DOL can be achieving, reasonable processing times. If anything, the workload is exactly what the DOL anticipated in 2004, 20 years ago. So it's unclear how the DOL continues to inadequately perform their duties and continually compound processing times and backlogs. Each month, we're seeing these processing time increase. It doesn't make any sense. So, we've talked about what the delays are, the current state, what's causing them, and how are the delays then impacting corporate immigration programs? As I was mentioning, 7 months to obtain a PWD or prevailing wage determination, plus 2 months to complete the minimum recruitment period, and then 13 months to receive a PERM adjudication. So 22 months total if you're running the process sequentially, and a best case scenario if everything moves in those estimations. I think how it's really impacting PERM programs, even if you're a company with a successful batch program, meaning that the prevailing wage determination and the recruitment period are already completed, you keep those evergreen or you keep them valid, so that as soon as you confirm an employee meets the qualification for that batch, you're eligible to submit the PERM application. You won't see a PERM approval for 13 months or over a year. And what that boils down to is companies are facing more max out cases. And that means that companies are facing, work authorization gaps for their talented employees that we're recruiting and that they're sponsoring through the green card program, but have a limited ability to keep them work authorized in the US while they're supporting a green card effort. Because as you may or may not know, the green card process or anything adjudicated through the PERM does not confer any work authorization for the employee to continue to work for your company. So you have to run 2 processes in parallel. You have to maintain an underlying work authorization for your employee while you're sponsoring the green card. And what we're seeing is as these green card processes are taking longer and longer, we're seeing employees just max out or run out of their underlying immigration work authorization. They're running out of H-1B or L status and creating some significant challenges for the company. And companies are having to get really creative with either rotating employees abroad, or if it's a short gap in work authorization, putting folks on a leave of absence. So some pretty expensive or challenging situations for both the company and the employees. Another consequence we're seeing because of these long processing times, I'm seeing employees really vet new employers based on their green card sponsorship tenure. So companies that have maybe a year-long tenure with the company before the company will sponsor green card, employees are really considering that before taking on a new job, because if they are in year 4 of their H-1B, they have not already secured a priority date or the ability to extend their H-1B beyond the 6-year max, they can't move to that company and successfully stay work authorized in the US throughout the green card sponsorship process. So that's causing some problems in employee mobility. The other thing is I'm seeing employees say they don't want to leave companies because they are in the PERM process. So again, it's creating a lot of immobility from the employee side. So what are some possible solutions to mitigate delays? I mean, it's tough out there. Again, even in a successful batch program to not get a PERM approval for 13 months is incredible. I think the first solution I'll recommend here is that companies need to be proactive in initiating the green card sponsorship based on the tenure policy. So I've worked with clients and consulted with companies in the past where they leave it in the employee's hand, that the policy says they'll kick off the green card sponsorship within 90 days, but it's in the employee's hand, like that the employee has to be apprised of the policy and that they want the employee to initiate that process. I think if you're really being mindful of the program, I think the employer needs to help support and kick off that process in collaboration with the employee so that you're not wasting any time in the initiation process. The other suggestion here is to check in with your immigration counsel to ensure that when the green card process is initiated, that the green card initiation includes an assessment for EB1, whether that's a multinational manager or outstanding research or a foreign national with extraordinary ability. And it includes an assessment for national interest waiver. If your company has not explored the national interest waiver in the past, I think consider this a time to include that in the assessment process. Again, make sure that your immigration counsel has that baked into when they kick off the process, so you're not leaving any potential pathway undiscovered, unnoticed, because the EB1 and the national interest waiver, NIW, offer such expedited processing times. It makes sense that there should be a baked in assessment. In the past, I think some employers were reluctant to process national interest waivers on behalf of employees because the sponsorship of the national interest waiver does not tie directly to the company. But in these times with very lengthy PERM processing, it makes sense for both the company and the foreign national to seriously explore. I know there's a lot of conversations out there that, NIW is really buzzy, that it's going to be the solution to PERM, whether in response to layoffs or these lengthy processing times. I think the reality is that it's not going to work for everyone. So I don't like selling NIW as the antidote to PERM because it's not. Not every employee is going to qualify, and not every company is in the position to support these national interest waivers based on the work that the company does. So don't get caught up in that's the solution here, but definitely bake it in to explore with your counsel to understand if this is even a feasible pathway for you, because maybe you weren't considering it in the past. I think what is going to enhance your program is just exploring the options of EB1 and national interest waiver for your employees to ensure that they know that they've been vetted for those potential benefits. The third recommendation I want to make here is to work with your immigration counsel to review if your program can benefit from batch. So this is often something we see in big programs, but it doesn't mean it's exclusive to big programs. What you want to do is look for sponsorship patterns of the same position and the same location. And like I said, it's great for big programs that have the numbers to support this. But with good reporting, you can identify patterns in your sponsorship with an organization, perhaps by a manager, and start picking up on whether there are opportunities for batch. And again, the benefit of batch is by batching, you keep a evergreen or a valid prevailing wage determination. So you eliminate that 7-month processing time to secure the determination. And then you ideally also have already recruited. And so you're also being efficient with your dollars in a cost containment era if you are leveraging recruitment, the advertising over multiple foreign nationals or multiple applications. So that's something to seriously consider, but you do need good reporting and good partnership with counsel to make that happen. The fourth and final opportunity to mitigate delays are consider concurrent recruitment strategies. Again, this isn't going to work for everybody, and it's only available if the prevailing wage determination is certain and that the company is comfortable with the salary range being above the prevailing wage determination. So I have many clients that this is very easy to do because we have predictable OES SOC codes and wages associated with their sponsorship program. If you're a newer program or have a lot of hybrid positions, this could be a little bit more difficult because it may be harder to predict where the prevailing wage determination is going to be if you don't have an established program you're going to be flying a little blind into what your salary wages need to be or ranges need to be when you're listing out on the recruitment. And so the risk with proceeding with recruitment before a prevailing wage determination comes in is that you might have to restart or repeat some recruitment efforts, or at least the ones that require the wage. So if you do have to repeat, it often ends up extending your recruitment period, which then eliminates the benefit of doing this concurrent step. The benefit of concurrent recruitment strategies, it's really you're carving out maybe 3 months of the processing time. So could be significant for some of your max out cases, but in the long run isn't moving the biggest needle, which is, that it takes 13 months to secure PERM approval from the Department of Labor. So that leads me to talking about technology for practicality. I think within our industry of U.S. immigration practice and many others, folks are really quick to say tech is going to be the solution for efficiency. And because PERM is a technical practice of immigration law, I think leveraging technology here is going to be a huge help and really important. With so many things, I think you want to make sure you're framing how technology is a supporting solution to efficiencies is critical. When I think about framing efficiencies and solutions to PERM and solving for PERM processing delays, I consider how PERM requires consistent job description and minimum skill sets, validity dates for prevailing wage determination, recruitment postings, filing windows, just a ton of dates to consider. Also considering the dates that align with the company's green card sponsorship policy, whether that's tenure or other timelines. And then the other thing that you need to be considering with PERM is maintaining underlying work authorization for employees. That's all to say that the dates and timelines are huge, and consistency in content for job description, minimum requirements are critical. So make sure when you're working with your counsel, you're understanding how the immigration case management platform supports these pieces. Because in theory, an immigration case management platform should have reporting that in theory captures all these PERM program management requirements. But you want to make sure that the following pieces are in place for meaningful insights. So the biggest component to an immigration case management software platform is its reporting power for the PERM process. But you want to make sure that the data collection methods are sound, that they're reliable and standardized, that data validation, the process to assess the quality and completeness of the data entered, and that through the data collection, the data validation, that the report you're seeing makes sense to you. So I know that in the past, I worked with clients that we, dump them a report and they're like, I don't understand what this means. So if you're in the driver's seat here as the HR immigration mobility, if you're getting a report that you don't understand, get a better one. You should be able to drive insights on where your program's at, how are things moving, and then look at the opportunities for efficiencies. So some of the most helpful reports I've used in the past and currently is reports that clearly identify all employees in the program and where they are in the green card sponsorship. So this should be a very easily digestible report of, not yet started, in the prevailing wage request stage, in the recruitment stage, PERM application pending. Like you should have these in buckets and sort of understand where all the employees are. And then also, see max out statuses. So you know who needs to move through the program faster, who's a concern that may lose work authorization. So one quick snapshot of your whole program. The other reports that I like to see for my clients are a report that spits out, the sponsored positions and locations, because this allows you to pick up on those patterns to see if batch works. So if you're a mid-size or a smaller program, you're not going to have batch for every program, but you're going to start seeing some trends that we sponsor, 4 software development engineers every year. Let's start thinking about developing a batch for them or, whatever the position might be. You also want to see which positions are qualifying for EB1 because there's going to be a trend there of which candidates we can start supporting on their EB1 journey. The other reports I like to produce for my clients are department team-based reports. So you can review the sponsored employees by department, by manager, by cost center to get an overall understanding of the structure within the organization. Because if there's a lot of disparity in job title under the same manager, maybe there's an opportunity to partner with the HR stakeholders to standardize job descriptions, to standardize job titles, not only for, the HR and the internal business, but to then reflect back into moving into a batch program for that department. Okay, so with that, I'm going to bring in my producer, Finn, to run through a few scenarios inspired by real world challenges that I've seen global mobility professionals face with PERM processing delays. We're going to change up a few details to keep the inspiration of these scenarios anonymous. But my hope is that if you're listening, at least some of these scenarios will resonate with what your program is facing, and that the suggestions I offer provide some direction on how to solve your company's unique business problems. Finn?
All right. First scenario is a global mobility manager is trying to fix bottlenecks in their company's PERM recruitment process, as PERM related delays are causing a lot of anxiety for the company's foreign national employees. Here's the info we have on this individual and their company. It's a global mobility manager at a Series C startup. They have about 10 years of experience in the industry. Their internal team size, they have one U.S. immigration specialist who's working underneath them, so 2 folks on this team. They work with one of the large U.S. immigration law firms as their partner law firm. Around 354 national employees in the U.S. Their green card sponsorship threshold for foreign national employees is they start the process 6 months after a foreign national employee joins the company. And they list their 2024 pain points as sort of dealing with increases in hiring and lack of an efficacious technology platform. So the question here, Laura, is how would you consult this global mobility manager to address recruitment bottlenecks, make the PERM process more efficient, and address their foreign national employees' anxiety?
I think a program this size may have batching opportunities. So I'd want them to, we need to audit the data because it sounds like there are gaps in reports, and we need to audit, cases that were recently filed, cases that are in the pipeline, because we want to pull data to understand for all of these cases recently filed to anything in the pipeline, what's the position title and location, to give us a quick snapshot of, is there any opportunity for new cases that are rolling on to leverage the prevailing wage determination from these previously in-process cases, or recruitment from these previously in-process cases. And so where we would sort of start with that, and then with that data, start creating a batch program, meaning filing multiple prevailing wage determinations, even without, new cases being initiated, just keeping them valid, because it takes so long to receive the determination. You want to, as soon as you receive one, almost file it again, because it's going to take 7 months, up to 7 months at this point, to receive a new determination. And the prevailing wage determinations may only be valid for a few months, depending on where you are in the year and when you receive them. So that's my initial recommendation, is to collect data, audit the data, get some reports to immediately take a look at batching. The other immediate action item to take is to ensure there's regular feedback loops to the employees in the process. So not just those that are immediately initiating their green card cases, but those that are sitting in these sort of pending application states. A no update email goes a long way to minimize some of the frustration for employees. They would know that there's delays at Department of Labor, but just a regular check-in, no update email from Immigration Counsel goes a long way.
Cool. All right. Scenario number 2. An HR director just lost an internal team member who managed the PERM filings at her company. Here are the fast facts on her and the company. It's a hardware manufacturing firm. She has about 12 years of experience, but only about 3 in the U.S. immigration space. She's got 4 team members across various HR functions, but none dedicated to immigration now that that direct report who handled PERMs left. They do work with a mid-sized immigration law firm in the U.S., have about 104 national employees, And their green card sponsorship policy is to start the process sometime after the first year before national employees tenure at the company. And then final thing, they list their 2024 pain points as, really lost institutional knowledge about U.S. immigration with the latest departure. And the HR director is wearing a lot of different hats. So the question here is, how would you advise this HR director on getting up to speed with the PERM program while wearing many different HR hats and taking over the immigration function for the company?
Yeah, I think the first thing the HR director needs to do is dedicate a half resource, or better yet, 2 half resources. It sounds like their HR team wears multiple hats, needs to play a lot of functions for the company. And at a program this size of 100 U.S. foreign nationals, I'm not sure you need a fully dedicated person, especially given, that they have many functions, but there needs to be at least one person that understands, but better yet, 2 resources that are dedicated at maybe a quarter or half time, then share responsibilities and be backup. So that's the first thing the HR director needs to do, is identify who's taken lead and point and backup within their team. And then the second thing is, once that resource has been identified, is to request training from immigration counsel. So we're going to have to, make sure this individual in the company knows what's going on, what the PERM process is, to be fluent in the world of acronyms that is U.S. immigration. And if counsel wasn't maintaining a protocol document for your company, request that the immigration counsel build this protocol document with the newly identified resource. So that way it's a half training opportunity for your newly appointed U.S. immigration HR lead, and not just on the U.S. immigration sponsorship program, but also training that individual on protocol. So develop that together. Many immigration counsels will have sample documents. So if you don't know where to begin, you don't even know what that should look like because of the recent turnover, take a look at a sample, have the immigration counsel walk through, like, what does it mean, and have, regular meetings to flesh that out. Developing a protocol document will allow the HR team to preserve institutional knowledge. So if there's any future turnover for whatever reason, at least there's this protocol document that remains to serve as a training document for the new person appointed.
This next scenario is a bit different. Most of our scenarios thus far have been from the perspective of the leader of the immigration or global mobility team. This looks at somebody who's a bit further down the totem pole at a company. So a senior coordinator of U.S. immigration was asked by her superior to draft a new company policy for refiling PERMs for national employees that request EB preference category changes or who experience a significant job change. So fast facts about this company and this individual. The industry is a fintech company. The senior coordinator of U.S. immigration has about 5+ years of experience in the field. She has 2 superiors, one who is a manager of U.S. immigration, and then the highest person on her team is the head of immigration and mobility of the company. The company works with a large U.S. immigration firm, 4 national employees, about 550 in the U.S. Their green card sponsorship threshold is that they start the green card process immediately upon a foreign national employee joining the company. And they listed their 2024 pain points as, rapid increase in hiring in 2024 and a lack of accurate data in their case management platform, which is a common problem, I think, across the industry. So the question here is, how would you consult this senior coordinator on developing the first draft of a new PERM policy for her company?
Yeah, the first thing I think of is to make sure you get all other HR stakeholders involved, talent acquisition, HR analyst, benefits comp team, because we want to make sure the immigration policy support job changes that's in line with how the overall organizational structure understands job changes. So if they're inline promotions, does that require a new PERM process? How does the company consider these things? For example, U.S. immigration defines manager in a very specific way, whereas we don't know how the company defines manager. And so we want to make sure We understand if those definitions of manager from the internal organization of the company align with what U.S. immigration sponsorship permits, because we get into some really uncomfortable conversations where within an organization, someone's title or consideration is manager within the organization, but it doesn't fit the definition of how the U.S. Immigration Service defines manager. And so we want to outline, those types of issues in the policy, saying the company will sponsor X level for a manager because we've already vetted how that fits both the internal organization and the immigration definition. And also when there are job changes. So I know often within organizations, there's like technical roles that go from like entry to senior. And then often there's like a manager. And so how are the different promotions considered? When is the job considered substantially different within that ladder? Because that is going to align with whether there needs to be a new employment-based sponsorship effort based on big job changes. And we want to make sure that the company considers job changes in the same way that the government does.
Last scenario here, a head of global immigration was just notified of a rift that will take place at their company in April, where about 254 national employees are expected to be laid off, many of whom have or had pending PERM applications. Fast facts about this company: it's a pharmaceutical company. This head of global immigration has about 20 plus years of experience in the field. They're experienced. 7 folks on their internal immigration and mobility team. Again, another company that works with one of the large U.S. immigration firms. They have over 1,800 foreign national employees. That's prior to this upcoming RIF. Their green card sponsorship threshold is 1 year after a foreign national employee starts at the company. They're eligible for green card sponsorship. And they listed their 2024 pain points, no surprise here, as dealing with the reduction in force and cost containment, sort of a parallel to that pain point. So the question is, how would you consult this head of global immigration to lead their team through the upcoming RIF? They have 1 internal team member and 1 contracted team member from the company's immigration law firm that handle and file over 250 PERMs a year on average. So it's a big PERM program.
So the biggest threat to a large program is a reduction in force. And while many foreign national employees are impacted, the relevant data to understand and immediately analyze here to understand the impact of future PERM filings will require an analysis of laid off U.S. workers. So to clarify, the test of the U.S. labor market is always meant to protect U.S. workers. That is what the PERM program is centered around and why the DOL manages all these compliance efforts. So we need to immediately analyze what U.S. workers were laid off to understand the impact to the remaining sponsored foreign national employees and to understand whether there are impacts to the in-pipeline PERM filings or not. So the order of operations in this case is, of course, to file PERM cases that are eligible for filing as soon as possible before the date of the layoff, and then to assess the pipeline of PERM cases. So again, that's where you're going to need the data for any and all laid off U.S. workers, because if U.S. workers are laid off in the area of intended employment in the same or similar occupation as any to be filed PERM case, essentially that PERM case cannot be filed for 6 months, or the company can embark in a very specific compliance process of notifying the laid off U.S. worker, invite them to apply. Many companies don't proceed down that path. They just stop filing PERM applications for 6 months for any relevant sponsorships. So it effectively puts the PERM program on hold for 6 months in the area of intended employment and in same or similar occupations, which we pretty broadly define that to ensure compliance here. This is likely going to cause some additional costs for these PERM applications that are in the pipeline, because if PERM applications are unable to be filed and have to be on hold for 6 months, it's going to cause likely refiling of prevailing wage requests, likely repeating various recruitment efforts. So perhaps placing new ads, and depending on what markets you're placing these ads in, those can be quite costly. So that's kind of managing the in-perm process analysis. And then the third recommendation here is to offer exit consultations to the impacted foreign national employees to make sure they understand their personal compliance requirements, their grace periods, and how they can manage and navigate their statuses in the wake of a layoff. And then the final piece is to withdraw any pending PERM applications for terminated foreign national employees. You want to withdraw the PERM application to avoid any audit liability, because if the PERM application remains on file, even if that employee has been terminated, the company would still be required to respond. So best to withdraw after confirmed termination of the employee. So wrapping up with some final thoughts here, I think it's tough. PERM processing delays continue to tick up. We'll stay tuned for Brad and Steven's litigation that hopefully chips away at these unreasonable processing times we're seeing from the Department of Labor, because I remember, pre-pandemic, we were getting PERM applications approved in under 6 months, which feels like both a lifetime ago, but also like just extraordinary fast processing times. And if the Department of Labor can really have promised to process these applications in 60 days, I don't understand, especially under the new flag platform and a shorter ETA 9089, why it would be taking the Department of Labor so long and continuingly longer and longer to adjudicate. So stay tuned. We feel your pain here. To wrap up, as you all know, episodes are released every Monday on Spotify and YouTube, soon to be Apple Podcasts. If you like this episode, I hope you'll consider subscribing to the Business Immigration Benchmark on Spotify or on WR Immigration's YouTube. I also recommend you follow WR Immigration on LinkedIn so you can catch up with updates about this podcast, as well as updates from my WR Immigration colleagues who are leading some really interesting conversations over on that platform. Please reach out and connect with me on LinkedIn. Send me a DM with any questions, comments, or feedback on this episode or things you'd like to see in the future. You can also send feedback, questions, or suggestions to my producer. His email is in the show notes. Thanks, everyone. See you next time.